On behalf of the Chief Justice and the judges of the Federal Court of Australia, welcome to the Court's Employment and Industrial Law Seminar for 2024. The judges of the Court present this evening include Justice Collier, Katzman, Goodman, Wheelerhan, Snaden, Kennett and Dowling. I'm speaking from Brisbane, known as Meanjin by the traditional owners of the land where the court sits, the Turrbal and Jagera people. We're at least expecting today about 140 people here in Brisbane, about 250 in Sydney and about 50 in Melbourne, as well as over 600 people watching the live stream. Now, all of us here are bound together by our work in employment and industrial law, whether as lawyers, tribunal members, judges, or in another capacity. The importance of employment and industrial law to the Australian community is profound and fundamental. There are over 14 million people in employment in Australia, and the working lives of every one of those people is affected by the laws governing their employment, laws that we all play a part in administering. The last year has been very significant for the practice of employment and industrial law in the Federal Court. For example, we have had substantial legislative changes, which you will hear about tonight. We have had the appointment of several new judges with extensive backgrounds in employment and industrial law, and we have recently launched a new general protections list on a national basis. All of these matters reflect the importance of employment and industrial law to the Australian community and to the work of this court. Now, I'd like to commence with a few statistics about the work of the Federal Court in the last year. Can I have the first slide? This slide shows the total number of employment and industrial relations matters filed in the Federal Court over the last 5 years. It's worth noting that it generally shows a slight downwards trend in filings in the Federal Court. That is in contrast with the FCFCOA, where there has been an upward trend in filings over the last 3 years, which you can see from the next slide. The next slide, please. Oh, I'm sorry. You can see that there was a steep decline in filings in the FCFCOA during the COVID period, and the numbers have risen since then, but not nearly back to the same levels as pre-COVID. I'm unsure what has caused these trends in the Federal Court and the FCFCOA, but as practitioners, I'm sure that you all have some theories, and I'm sure that all our judges would be interested to hear your theories after the seminar. The slide also shows that there are generally about 5 times more cases filed in the FCFCOA than in the FCA. Next slide, please. This slide compares the numbers of filings in the various practice areas of the Federal Court. You can see that corporations cases account for just over 20% of the court's work, followed by migration with about 13%. And then you can see the green bar, which is employment and industrial relations, with nearly 12% of the court's work. And so that demonstrates the importance of this practice area to the overall workload of the court. Can I have the next slide? It's now time to introduce our eminent first speakers, Luke Tiley and Shay McCartney. Luke Tiley is a director and principal of Hall Payne Lawyers. Luke primarily practices in industrial relations law for employees and trade unions. Luke was based in Brisbane for many years, but in 2023 relocated to Melbourne to head his firm's practice there. I'm told that he's enjoying the football in Melbourne, but perhaps not the weather. Shay McCartney is a partner in Clayton Utz. In contrast, to Luke, she focuses on advising corporate and government clients, particularly in employment and industrial law. Shay is a member of the Clayton Utz board and tells me that she has learnt firsthand what every frustrated lawyer should know, that even though you may give really good legal advice, in practice it can be surprisingly complex to implement. Please welcome Luke and Shay.
Good evening. First slide, please. Next one. So tonight, just by way of an overview, I'm going to talk about casual employees from both an historical and a contemporary perspective. And Shay will talk about independent contractors from both an historical and a contemporary perspective. And then the two of us are going to discuss how we think the recent legislative changes might play out in practice. Next slide, please. At the outset, in terms of my remarks, I just want to gratefully acknowledge the assistance of my colleague Max McGregor, who played a very significant role in preparing these remarks and also for attending a meeting with the judge and others while I was extremely busy relaxing on the other side of the world. So how do we know whether a worker is a casual employee or not, as the case may be? Next slide, please. The prevalence of what became known as the long-term casual, an employment relationship where employees are categorised as casuals in spite of their substantially permanent role, led to a series of cases being brought by employees, including against labour hire firm Workpac. In Skene in 2018, the full court affirmed a substance-based test which looked at the totality of the relationship to determine the nature of employment. The substance test for casual employment assessed the conduct of the parties, the real substance, practical reality and true nature of the relationship. The firmness of an advanced commitment, in addition to the relationship's duration, would combine to create a continuing, not casual relationship. Now that test was affirmed following Workpac in a different factual scenario in a case called Rosado, and I know that there's a number of people in the room and watching tonight who are involved in both of those cases. To that point, if it wasn't already, one would have thought the concept was settled in Australian law. Those decisions led to significant controversy, and a number of employer groups in the business community took exception to those decisions, and employer group, the Australian Industry Group, suggested that the back pay bill as a result of those decisions could be up to $14 billion. Next slide, please. Workpac appealed the full court decision in Rosado to the High Court, and during that period of time, the then coalition federal government announced its intention to intervene in the case and to legislate a new definition of casual employee through the Fair Work Act. Now that was what I will refer to tonight as the first new Section 15 capital A, which in simple terms sought to determine the issue on the face of the employment contract. And when Shay speaks a bit later on about some of the independent contractor cases, that's a theme that will re-emerge. Critically, the new definition in the first new Section 15 capital A also excluded consideration of any subsequent conduct and noted that a regular pattern of hours does not of itself indicate a firm advanced commitment to continuing and indefinite work. So this definition thus prevented prospectively any future reliance on the substance test from Skene. Following the introduction of that definition, the High Court in 2021 overturned the full court in Rosado, comprehensively rejecting the substance-based test from Skene and instead preferring what it described as a rights and obligations test, saying that the character of the relationship between the parties is established by the rights and obligations which constitute the relationship. Next slide, please. Which takes us to the beginning of what is the present situation. When the Albanese government was elected in 2022, it set about to comprehensively reform the Fair Work Act, including by redefining casual employment. Next slide, please. Critically, the new definition, the government's intention was made clear in the explanatory memorandum, which stated the government's intention to improve job security by replacing the existing definition of casual employee with a fair and objective definition. The explanatory memorandum explicitly referred to both Rosado and Skene and made it clear that the Parliament was seeking to legislate the substance test for casual employment from Skene by introducing the second new Section 15 capital A. And I won't read out in full the relevant passage from the explanatory memorandum. Suffice to say that the government very clearly grabbed a hold of the earlier decisions in Workduck and Skene and sought to embrace them through its legislation. Under the new Section 15 capital A, as it is now, having commenced on the 26th of August this year, the question is ultimately whether the employment relationship is characterised by an absence of a firm advance commitment to continue an indefinite work. The indicia in subsection 2 guide consideration of whether such a commitment exists, including, for example, by reference to the real substance, practical reality, and true nature of the employment relationship. The indicia also relevantly refer to whether there are full-time employees or part-time employees performing the same kind of work and the freedom of the employer to offer or not to offer work. The explanatory memorandum in paragraph 329 contains a detailed worked example of how the Parliament intended or envisaged the second new Section 15 capital A would work. And again, I don't need to read that out, but I commend that to you. I should also direct attention to Section 15 capital A subsection 5, which contains two mechanisms for a casual employee to become something other than a casual. It is apparent from the explanatory memorandum that that subsection is intended to give greater certainty to the parties by providing those mechanisms to address any controversy or concern about the casual status of an employee. The first mechanism is in subsection 5A, which cross-refers to the casual conversion provisions that exist elsewhere in the Act. Those are in Division 4, capital A of Part 2.2. Those provisions are beyond the scope of our discussion this evening, but you'll find there a fairly straightforward regime for how conversion can or can't be achieved. The second mechanism exists in subsection 5B, which is perhaps the orthodox method of changing one's status from casual to something else, which is in simple terms by the agreement of the parties. So that's all I have to say for now. Over to you, Shane.
Thank you. When I suggested to one of my lawyers that I was doing a presentation with Luke on this issue, he did suggest to me, was this a debate and what was the win? He suggested that the win should be that the winner gets to decide what the definition of employer is. So I'm quite happy to take that challenge on. But no, that is not the case. But it does sort of bring to mind the point that this many years on, we're still backing and forwarding as to what is the definition of an employer and an employee. And I'll go through in a second the common law tests historically and then the legislative changes. But I think there's a couple of important things to bear in mind. One of them was I did have the opportunity to interview President Hatcher very recently, which I was incredibly grateful for. And I asked him a question about, did he think it was strange that, this continues to be a matter of change. And he did draw to my attention the point that under a lot of the legislative changes, that the definition actually to some extent becomes less relevant because there are obviously more jurisdictions for employee-like categories. And so we do need to be careful not to just focus on what is the definition of an employee. The other thing that's important to note is that obviously different pieces of legislation have expanded definitions of employee or specific definitions of employee relevant to, for example, superannuation or payroll tax, and this definition won't necessarily be relevant to those, so important to keep that in mind. If you could click through, sorry, and the next one, and one more. Now, people who know me to present know that I'm terrible with PowerPoint. I hate it, and that I'll talk a lot and then flick through 10 slides. So please don't get stressed if you like a lot of structure. So if we talk about the history, I guess, previously and before Stevens and Brodribb saw milling, we had a definition that focused entirely on control, and when that matter came before Stevens and Brodribb Sawmilling, which was a place where there was a matter where there was a dependent company owned a large sawmill company, and this issue of control was really tested. And what became apparent was that while you might say who has control, that obviously sometimes the contract can say that there's control, but there's no real control. And then sometimes there can be real and genuine control, but the contract actually seems to specify that there isn't any. And so what is actually real control is often quite hard to understand. And so in that case, the court found that a better test was the multifactorial test, where we looked at several indicia regarding whether a person is an independent contractor. And this was then not an exhaustive list, but supposed to be a bunch of different factors that we look at and the types of things that we take into account. The problem, of course, though, with that test is that it does also lead to uncertainty, because what employers want, and maybe employees want too, is to be able to know what is the relationship at the time of formation. And if you're looking at that test over the lifetime of the relationship and these different factors as they go on, and I'll talk about what those factors are in a moment, then you could have something that was one relationship at the beginning and uncertainty as we go on. We then went to Hollis and Babu in 2001, and that case related to a cyclist who was struck whilst wearing an outfit that had the name of the employer, which was Crisis Couriers on it, and the issues were whether the company was vicariously liable for the courier driver's negligence. Sorry, the courier driver was wearing the obviously not the cyclist. And the High Court looked at the issue of control, but of course, again, it was something that was quite difficult to assess in circumstances of a courier driver relationship, because they don't have necessarily direct day-to-day control, but they might ultimately have to report to and abide by the requirements of the company. They also looked at how they were paid, and that was a relevant factor, but again, not determinative. And ultimately, what the court found was that you have to look at the multifactorial test, but then whose business is actually being undertaken. So looking at it on a holistic basis, is the courier driver running their own business, or are they running a business for the company or the head contractor? So fast forward then, so where we, not fast forward on the slide, sorry, thank you. So where we left it was that you took a holistic approach, which took into account a number of indicia and the multifactorial test, but on a holistic basis. We then had Jamasek and personnel contracting, where the High Court basically overturned those decisions and said, at the end of the day, these are sophisticated relationships. If the parties have put them down into writing, provided that the contract itself is a contract that represents a contracting relationship, and that was the difference between the two cases. Of course, one was found to be a contractor and one was found to be an employee. But what they said is that the contract is king. So if in looking at all of the elements of the contract, it is genuinely an independent contracting relationship, it will be a contracting relationship. If when you look at it, it calls itself a contract, but is in fact an employment relationship, then it will be an employment relationship. Next slide, please. So what is old is new again. So when the reforms that Luke just spoke about were introduced, there was a very clear mandate and purpose that certainly Minister Burke spoke about, which was to push towards permanent full-time employment and to make other forms of engagement, contingent workforces, I don't think unpalatable was his word, but that certainly, that the drive was to push towards employment. And in these reforms, and if you could flick to the next slide as well, please. One more. And in these reforms, in particular, the introduction of a new test now, it does make me laugh in any circumstance where the ordinary meaning has to be given a new meaning, but the ordinary meaning of employer and employee involves an assessment of the real substance, practical reality and true nature of the relationship. And these goes back to the matters that Luke was talking about just before. And so if I could then click on 2 more slides, please. 1 more. So if we look at what is the real substance, practical reality, we're back to the multifactorial test. And the explanatory memorandum was very clear that the new definition was intended to effectively, was made in the knowledge of Jamasek and personnel contracting, and was to effectively overturn those decisions. And so when looking at what is the real substance of the relationship, we have to look at control, as we talked about before. So what is the right to direct the worker? Whether they have permission to delegate the work. And what's really important there is, often contracts will say there is a right to delegate, but only with the permission or only in very limited circumstances. And the courts have looked at that and considered whether that is in fact a genuine right to delegate or not. And I think that will be even more so the case now that contract is no longer king. Whether the worker can perform the services for multiple parties. And again, it might say that this is not an exclusive contract, but if in reality it's at all times, and there are very strong clauses perhaps within the contract that talk about restraint of trades and confidentiality, and mean that the reality is that you couldn't actually perform work somewhere else, and that's obviously not going to be the case. The level of integration and degree of independence, and this is where we go back to that holus and bubu. Are you presenting yourself as the worker of the courier company, or are you presenting yourself as running your own business, and what is the actual nature of that business? The level of integration, and often that can be quite difficult in our current times, because of course everyone needs to get onto someone's computer system to do any work. And so the more that those services are integrated, the more that will actually be a really difficult problem. So can you maintain a separate email address? Can you have only limits to what in the computer system the worker can get, for example? How the worker is paid, and this is always a big one, because of course people are usually paid by the hour, and of course employees are usually paid by the hour. And so it's quite rare in our day and age, by that nature, all law firms are probably that we can't seem to get away from the hourly billing. So until someone works out how to do that, that's going to be a matter of tension, I think, in these contractor tests. And then whether the worker is required to carry out their own workers' compensation and liability insurance. And that's a really critical issue where, because of the extended definitions of workers' compensation, for example, often it can be quite confusing as to whether they have their own insurance policy or are doing so because they're an employee or because they're a contractor. And so it's not just enough to say in the contract that they'll bring their own insurance. It's how does that actually work in practice? We might then flick just right to the end slide, if that's okay. No one watch the other slides as we go by. Luke, did you want to, I think, we're going to talk about the practical reality of how, because I'm conscious that I've already gone over. So I might ask you, employer groups say that they just want certainty in the relationship, but do you think that a casual employee, in accordance with the terms, remain a casual? So, there's this 5A clause that says, if you're a casual, you remain a casual until court orders otherwise. So is that the end of back pay, underpayment claims because you are a casual unless and until that gets changed?
No, is the short answer. Shay was good enough to telegraph. She hasn't asked me these questions, I had to check. I had an opportunity to check if I was right. But when Shay first asked me this, my initial reaction was no, because for 3 main reasons, or perhaps 2, the second and third are very similar. The first is that when you read 15 capital A subsection 5, it really appears to be concerned temporarily with during the employment and has nothing to say about what might occur after the employment. That's the first indicia that that's not what was the intention. The next is that obviously there's a well-trodden path to come off to this court or the circuit court or others to with a claim to say that you weren't truly a casual employee and you should be paid, for example, annual leave. It would be inconsistent with the scheme of the Act for that jurisdiction to be ousted, and you would expect there to be very clear express words if that was the Parliament's intention. That sort of instinctive reaction that I had is confirmed in paragraph 299 of the explanatory memorandum, which makes it clear that avenue is still there, and it looks at the matter. It doesn't look at the matter in a manner which differentiates between people who are still employed and want to say, hey, I'm a permanent employee now, or people who have finished their employment and want to say, I was a permanent employee then. The other thing worth mentioning about that paragraph is people will recall that there was a controversy in the Skene and Rosado litigation, I think definitely in Skene and maybe in Rosado as well, about the extent to which the casual loading that had been paid could be set off against any entitlements that were found to be owed as a consequence of the finding of permanency. What the explanatory memorandum says is that if a court is faced with that sort of claim and does reach the same sort of conclusion as to permanency, the casual loading does get set off against the liability for example, unpaid annual leave. That, of course, is only possible where the casual loading is able to be separately identified and quantified, and where there's a rolled up rate, obviously that might not be as easy to do. So that, I think, is a long-winded answer to your question, Shay. And I had a question for you, Shay, just to go back to what you just spoke about contractors. The High Court in Jamsek and Personnel emphasised the primacy of contract, or to use your words, contract is king. I've seen in the short time since those cases a number of contracts that have been made or varied where the parties have sought to avail themselves of those principles and verbal, if you like, the court into saying this is what they are. So if a contract has a clause which says, for example, the parties agree that the worker is an independent contractor and not an employee, if that sort of contractual clause still exists, what role do you see it having to play in a litigious dispute under the new provisions that you've told us about?
Good question. I could have even thought of it myself. Look, I think it does have a role to play, because I think it still was one. The contract is one of the indices in the multifactorial test, and but I think if I go back to I think it was the case of Porter and Transport Workers Union. It's one of my favourite quotes, which is the parties cannot create something which has every feature of a rooster but call it a duck and insist that everyone else recognise it as a duck. I'm pretty sure there's another case that also involves elephants, but Hillary tells me that that's not true and that I'm just imagining, but I'm sure it was something about, if you look at all the different bits of an elephant, you might not know what they are, but altogether it's an elephant when you run across it in the jungle. But so I think you can't just have that clause, but I think if the clause is one part of the many indicia that show that it is, I think that has relevance. And then I think also, there are some case law that talk about the parties, whilst just labelling something won't be enough, but where there is not much other evidence, the way the parties label something is of quite importance. And I think His Honour Justice Logan said that recently in a case of Hallam and Tancred, which was a case about partnerships and slightly, but I think that still is the case, that in the absence of other evidence, it will have some relevance.
And I think we might have time for one more question. The opt-out provision, you didn't get to explain it to everybody how they work, but I thought it might be helpful if you could tell everybody whether you think they're going to be utilised or to what extent.
Yeah, thank you. So this is the if you have a rate or an amount that is higher than the high contracting threshold, which is same as the high income threshold, so currently 175,000, I think it is, then an employer can issue a notice to, or an employee, I should say, can issue a notice to opt out of the provisions. And to say, therefore, that that definition doesn't apply, which would, of course, then lead to perhaps Jamsek and personal contracting being the relevant test, and if you draft your contract properly, presumably that being the relevant factor. But no, I don't think that they'll be used. And the reason why is because the wording of the Act says that the person can use that clause where they consider that the person may be an employee but for this notice. And so I think basically you've set yourself up to suggest that you don't think you've got a genuine contracting relationship, and then the worker can opt out at any time with no notice, effectively just issuing a notice to opt out, in which case you would go back to a common law test, but having perhaps as the employer sort of set yourself up to say, I'm worried that this is not a genuine independent contracting relationship. So I'd be very surprised if they're used by employers.
Thank you.
Thank you.
Thank you, Shay and Luke. Next, we have two very eminent and experienced barristers practicing at the Queensland Bar who will be speaking about the topical issue of sexual harassment in the workplace. April Freeman worked as a prosecutor at the Office of the Director of Public Prosecutions from 2004 to 2008, before commencing in private practice at the Queensland Bar. April's practice largely focuses upon employment and industrial law, as well as regulatory and disciplinary matters. Stephen Mackey practices as a barrister at the Queensland Bar also. Before that, he worked from 2006 to 2014 as a solicitor specialising in employment and industrial law. His practice at the bar is predominantly in the same areas of law. Please welcome April and Stephen.
Good evening, ladies and gentlemen. We've been asked to talk to you tonight about the new provisions in the Fair Work Act regarding sexual harassment. But before we do that, we thought it was important to take a look at how the law has, in relation to sexual harassment, has developed over the years. And invariably, that involves a consideration of how societal attitudes have changed over time as well. If I could just have the next slide put up on the screen, thank you. So currently, the key areas of legislation relating to sexual harassment is a patchwork of different pieces of legislation, including the Sex Discrimination Act, the Fair Work Act, a variety of state-based anti-discrimination laws, and we also have a variety of work health and safety legislation in each state and territory in this country. So, Stephen, generally speaking, what are the changes to the Fair Work Act in relation to sexual harassment?
Well, the big change is the insertion of Part 3-5A into the Act, which came into effect on the 6th of March 2023. And it has two main limbs. First, it has a sexual harassment dispute jurisdiction for the Fair Work Commission. Now, that jurisdiction is effectively a mirror of the Commission's pre-existing jurisdiction dealing with stop bullying orders. Now, while those provisions in Part 3-5A are new, that jurisdiction itself, in fact, came into existence in 2021. The second set of changes in Part 3-5A is the more significant one, or the more recent one at least. That creates a new civil contravention that expressly prohibits sexual harassment. That's section 527, capital D. And that took effect as a result of the Fair Work legislation amendment, Secure Jobs, Better Pay Act 2022. Now, these provisions are designed to complement the existing legislative framework, which April just referred to. Could I have the next slide, please? Oh, actually, no, don't. I like that slide. Let's keep it. If you look at this wonderful slide, which happens to already be on screen, you can see that the object of Part 3-5A is to give effect or give further effect to our international obligations, which are listed in that provision. Now, it achieves this by prohibiting sexual harassment of workers, people seeking to become workers, persons conducting businesses or undertakings. So there's that PBCU test that everybody involved in work health and safety law will be so familiar with, and providing remedies where appropriate.
So it looks like none of this is particularly new. We can see the dates up there range from 1979 to
58.
1958. It's been an issue within society for decades. What has changed?
Well, what seems to have changed is two things. First, there's been a significant cultural shift about what kinds of behaviour are and are not acceptable. And secondly, there's been an acknowledgement of how frequent unacceptable behaviour is. And if you look back at any old media, films, books, TV shows, you can see just how stark that shift has been. Sean Connery's James Bond, for example, makes a number of comments which must have been very, very funny in 1968, but are quite difficult to watch in 2024, where they are, quite frankly, just openly misogynistic. And while he's an obvious example, he's far from the only one.
Could I have the next slide, please? So unless you've been living under a rock for the last 7 years, you'd be familiar with the Me Too movement, which has had a significant impact driving awareness around this issue. Now, this awareness movement around the issue of sexual harassment and sexual abuse of women in the workplace grew to prominence in 2017 in response to news reports of sexual abuse by American film producer Harvey Weinstein. And while the phrase Me Too had been used on social media platforms for years prior to this, it was a tweet by American actress Alyssa Milano in October 2017 which sparked a social media phenomenon that raised awareness, gave voice to survivors and led to sweeping cultural and workplace changes, particularly in the US, but also around the globe. And Australia has not been immune to this social and cultural shift. Cue Grace Tame and Brittany Higgins. If I can have the next slide, please. Now, Grace Tame, a survivor of child sexual assault, set the tone for 2021 when she was named Australian of the Year in January for her role in raising public awareness about the impacts of sexual violence. A few weeks later, inspired by Tame, former Liberal staffer Brittany Higgins alleged she was raped by a colleague in a ministerial office in March 2019. Shortly after that, former Attorney General Christian Porter was accused of raping a 16-year-old girl in 1988, a claim which he strenuously denied. And in March 2021, more than 100,000 Australians participated in a March for Justice rally to protest sexual violence and harassment in politics while calling for an end to gendered violence. There has been significant media attention and focus on these types of cases in Australia. We don't have to go very far then, for example, former Neighbours star Craig McLachlan, who was acquitted initially in December 2020 of unlawful assault involving some inappropriate conduct during a production of the Rocky Horror Picture Show. If we could have the next slide, please. And how can we forget Mr. Lerman, the man who went back for his hat? This case was your quintessential he said, she said workplace sexual assault case, but it became much, much more within the media landscape. And as we can see from the opening remarks of His Honour Justice Lee's decision regarding the defamation proceedings, aka the Omni Shambles, this case resulted in two general groups of people arising: those who were disposed to be sceptical about complaints of sexual assault and who hold stereotypical beliefs about complaints of sexual assault, and then those who perhaps bought into the Me Too movement a bit more keenly, surrendering all their critical faculties. But as was insightfully observed by His Honour, for more than a few, this dispute became a proxy for broader cultural and political conflicts. Next slide, please. And we can see why when we look at the 5th National Survey on Sexual Harassment in Australian Workplaces that ARC did in 2022, where 1 in 3 people in the last 5 years had reported being sexually harassed at work, with 41% of those being women and 26% being men. So that's a third of the workforce apparently being exposed to this kind of conduct. So how has the law responded to this, Stephen?
Well, the starting point for this topic, especially on a federal level, has to be the Sex Discrimination Act of 1984, You can't look at the FW Act provisions in isolation because they were made with the existing SDA obligations in mind. Next slide, please. Now, the SDA prohibited sexual harassment from commencement, but it has changed a lot since 1984, like many people, I imagine. Dealing with the Act, though, for example, in 2013, it was amended to expand from primarily protecting sex, pregnancy, and so on, to also covering sexual orientation, intersex status, and gender identity. The recent decision of Tickle and Giggle for Girls Proprietary Limited discusses those changes in some detail. But the more recent changes to both the SDA and the Fair Work Act came from the same source. And that was a national inquiry by the Australian Human Rights Commission. Now, that inquiry was announced in 2018, following on from the Me Too movement. And its report was published in 2020. You've doubtlessly heard of it. That was the Respect at Work report. Now, that report made 55 recommendations in total, including proposed changes to both the SDA and the Fair Work Act. However, those changes happened in multiple tranches. So if this discussion is giving you a sense of déjà vu, there is a reason. But as far as the end result goes, when it comes to sexual harassment, the current SDA provisions essentially have three important aspects. First, they prohibit both sexual harassment and harassment on the grounds of sex of persons where the harassment occurs in a particular relationship or context. Second, it prohibits subjecting a person to a workplace environment that is hostile on the grounds of sex. And third, it imposes a positive duty on employers who take reasonable and proportionate measures to, among other things, eliminate the first two types of conduct as much as possible. So just dealing with that first point there, prohibiting sexual harassment, you can see it doesn't apply to every single situation. It has to fall within one of a number of specific relationships or contexts, which are listed in the SDA in some detail. Now, those contexts are quite broad. For example, while the provision applies to harassment of a fellow employee, it also applies where the harassment occurs in connection with the victim being an employee. So it could potentially extend to, for example, not just attending the work Christmas party, but attending a joint Christmas party with workers from a different entity, or staying in accommodation with the workers of a number of different subcontractors.
So you can see how this might create a variety of scenarios in this modern tech-heavy era where people might be able to engage in sexual harassment in ways which the employer, in fact, has actual very little control over those scenarios. For example, sending sexually explicit or implicit text messages to another worker on your work phone at a work social event, or sending sexually explicit photos to another worker outside of work hours, but whilst staying at accommodation that your employer provides whilst you're on a rotational roster, for example. We can see how the landscape for employers just got very complicated and fraught with danger in this day and age of social media, Instagram and Snapchat. If I could have the next slide, please. So that brings me then to vicarious liability. Now, under the SDA, Section 106 provides for that. And we can see that employers may be liable if an employee commits sexual harassment and the employer did not take all reasonable steps to prevent the employee from doing those acts. And so from a practical level, what that might mean is that employers are expected to have things like a sexual harassment policy in place, provide training for employees on how to identify and respond to sexual harassment, implement internal controls and internal complaints handling procedures, and take appropriate remedial action if and when a complaint is made. I could have the next slide, please. So in terms of the remedies that are available under the SDA, we actually have to go to the Australian Human Rights Act for those. And Section 46, capital P, capital O, provides fairly broad remedies for the courts in terms of any findings of unlawful sexual discrimination, including sexual harassment. They include things like declarations about the unlawful conduct having occurred, orders redressing loss and damage, including apologies, orders regarding re-employment, and orders regarding damages as compensation, including things like aggravated damages. Have the next slide, please. Now, as Stephen has already mentioned, an important milestone in the evolution of our sexual harassment law in Australia was the Respect at Work report that was issued following the inquiry in 2020. Now, the Commission's task was to review and report on workplace sexual harassment and make recommendations in relation to a number of things, including the prevalence, nature and reporting of sexual harassment in Australian workplaces, the role of technology, its drivers, including risk factors for particular population groups or different workplace settings, for our purposes, the current legal framework, existing measures to address it and examples of good practice and its impacts on individuals and businesses, including its economic impact. In the introduction to the report, the Sex Discrimination Commissioner observed that workplace sexual harassment is prevalent and pervasive, and it occurs in every industry, in every location, and at every level in Australian workplaces. Australians across the country are suffering the financial, social, emotional, physical and psychological harm associated with sexual harassment, and this is particularly so for women. This behaviour also represents a very real financial impost to the economy through lost productivity, staff turnover and other associated impacts. Overwhelmingly, the Commissioner heard through the inquiry that the current system for addressing workplace sexual harassment in Australia is complex and confusing for victims and employers to understand and navigate, and it also places a heavy burden on those individuals to make a complaint. Yet most people who experience sexual harassment never report it. They fear the impact that complaining will have on their reputation, their career prospects, and relationships within their industry or community. And throughout the inquiry, the Commission heard of the need to shift from the current reactive complaints-based approach to one which requires positive actions from employers and focus on prevention. If I could have the next slide, please. So that then brings us to one of the most significant changes arising out of this inquiry and the Respect at Work report, and that was the imposition of a positive duty on employers to prevent harassment and discrimination under the SDA. Now, this positive duty applied from December 2022, and it means that employers now have a positive duty, as far as possible, to eliminate unlawful behaviour such as discrimination on the ground of sex in a work context, sexual harassment in connection with work, sex-based harassment in connection with work, creating a workplace environment that is hostile on the ground of sex, and related acts of victimisation. Now, despite the Commission hearing about the complex nature of the already existing legislative framework, one doesn't have to go much further than looking at the guidelines for complying with the positive duty that was issued by ARC, which runs some 112 pages, to realise that things have got a whole lot more complex for employers. These guidelines, which the Commission now has new powers to inquire and enforce the duty against employers, involves things like businesses acknowledging intersectionality and having person-centred and trauma-informed regimes in place to deal with sexual harassment, and includes a number of standards that are required to be in these policies that relate to leadership, culture, risk management, monitoring, evaluation, transparency and the like. And that's just under the SDA. You don't forget about things like the obligations under work health safety legislation that require that employers provide a safe workplace for employees. Why then would you choose to commence proceedings under the new Fair Work Act provisions, Stephen?
It's a very good question because the two regimes are very similar. Can I have the next slide, please? Both use the same definition of sexual harassment, which comes from section 28, capital A of the SDA. I'm sure we're all familiar with it, but as it's so critical, I will just very quickly run over it. It's an unwelcome sexual advance or request for sexual favours to a person who is harassed, or other unwelcome conduct of a sexual nature in relation to the person who is harassed. Further, the conduct has to be such that it is reasonable to anticipate the possibility that the person being harassed would be offended, humiliated, or intimidated. So you can see it's got both subjective and objective elements to it, as well as a focus upon the particular situation of the parties. Both acts use that exact same definition. Both acts provide those protections to workers, broadly defined, employees, contractors, work experience students, future workers, PCBUs. Both provisions even apply to harassment that occurs in connection with the person being a worker, seeking to become a worker, or conducting a business or undertaking. The vicarious liability provisions are, again, very similar. Employers or principals may be liable for the conduct of their employees or agents unless they can establish that they took all reasonable steps to prevent the contravention. So the issues are much the same. And of course, in either case, the complainant ultimately has the right to commence proceedings in court. So this, of course, brings us back to the question, well, then why would you pick one over the other? Could I have the next slide, please? And it seems to me that the key difference is actually the process. So that is, unless you're seeking an interlocutory injunction, well, if you want to bring a claim under the SD Act, you have to make a complaint to the Australian Human Rights Commission. But if you want to make a complaint under the Fair Work Act, you have to bring your complaint to the Fair Work Commission. And in both cases, the relevant commission will try to conciliate the dispute. Now, you might pick one commission over the other based on, well, a range of factors, such as, is the complainant also seeking a stop sexual harassment order? Well, if so, the FWC is probably the place for you. There may be some particular expertise in one commission or the other that the complainant wishes to rely upon. The FWC, of course, has considerable industrial relations experience. So if you are interested in an ongoing employment relationship, that might be a place where you'd be looking at going. The AHRC, however, published those guidelines that April just referred to. So if you're interested in going through the guidelines in detail, maybe that is a better venue. It, of course, depends on what other complaints the complainant is making. The AHRC, as we all know, deals with complaints well beyond sexual harassment in the workplace. There are other matters in the SDA itself. And, of course, there is the Race Discrimination Act, the Age Discrimination Act, and so on. And let's not forget that, as I touched on earlier, the SDA prohibits not only sexual harassment, but harassment on the grounds of sex, which is where somebody engages in unwelcome, demeaning conduct on the grounds of sex, as opposed to direct harassment. Contrasted with that, of course, the FWC is familiar with all of the causes of action under Part 3-1. So you can see these are probably the different factors that a complainant is going to take into account when deciding where to go. Arguably, in fact, probably one might say not arguably, unarguably, one of the most critical factors will be whether or not the conduct occurred prior to 6 March 2023. Because if it did, well, your decision has just been made for you. It will not be the Fair Work Commission. A further distinction is that the FW Act proceedings is, of course, it's a civil remedy contravention. So that means, yes, the applicant or complainant has access to civil penalties, but individual respondents will be entitled to civil remedy privilege. It also means that the Fair Work Ombudsman has the power to either investigate alleged breaches under the Fair Work Act or if it wishes, even commence proceedings itself. Personally, I suspect that a factor in making these amendments was actually, in a way, the optics, making it clear that sexual harassment in the workplace is, in fact, a workplace issue. I don't know about people here or online, but periodically people have come to me and they say, Stephen, I know you practice in employment law, but do you know anyone who deals with sexual harassment? And I, of course, say, funnily enough, yes, I do. But it seems, for some reason, that amongst a lot of people, they seem to view these two as distinct concepts, distinct causes of action, distinct issues. But now if somebody picks up the Fair Work Act and thinks, okay, what are an employee's rights and obligations? One of the things they will see is protection from sexual harassment.
Sexual harassment is one of those unique areas of law where its central concepts, such as the definition of sexual harassment, has not changed a great deal since it was first introduced in 1984. But what has changed is how people view and apply those laws and how seriously we view contraventions of those laws. The Fair Work changes are significant in that it's the first time that sexual harassment has become a civil penalty provision, short of sexual, so harassment that's short of sexual assault you might take to the criminal courts is now being penalised by the federal courts. And when we look at how prevalent harassment in the workplace is, we can only hope that these changes will bring about the change required so that Australia can reclaim its position as leaders in tackling sexual harassment and provide employers with guidance they need and victims the support and redress that they deserve. But I think one thing that we can all agree on is that none of us want to be involved in an omni-shambles. Thank you very much, everybody.
Thank you, April and Stephen. We'll cross now to Justice Katzman in Sydney to introduce our final speakers.
Thank you. Well, welcome to Gadigal land. Can I pay my respects to the traditional owners? And can I thank the speakers in Brisbane for the work that they put into those presentations. It was quite extraordinary. At one stage, I felt like I was in some speed dating exercise. There's quite a lot of information to absorb. Hopefully, we'll retain some of it when we leave the courtroom. It's my pleasure to introduce the Sydney speakers. They are Catherine Bembrick and Philip Boncardo. Catherine has been at the bar for 9 years, after 9 years as a solicitor and then senior associate at Allens Linklaters. She's very bright, very able, and her practice takes her not just to employment and industrial relations areas, but intellectual property and competition law. She obviously has a career on the federal court down the track. Now, Philip is a little younger. He was admitted to the bar in May 2017 after 5 years as a solicitor, including 2 years as a national legal officer for the beleaguered CFMEU. Before that, he was a tipstaff to Justice Brereton in the Supreme Court. The CVs for both of them make it clear that where they practice, Catherine at 5 Wentworth and Philip at Wardell Chambers. So for the solicitors present, you might like to make a note of that. Philip and Catherine are going to speak about the evolving workplace and legislative responses, and their agenda will cover employee-like workers and the gig economy, the right to disconnect, what it is and how it will work, serious contraventions and pecuniary penalties for underpayment contraventions, and the current and future situation with adverse action proceedings. So over to you, Catherine.
Thank you, Judge. Good evening, everyone. Well, we've heard tonight about a number of legislative reforms of significance, and Phil and I will address some further reforms which respond to what we've described as the evolving workplace. Now, when we think about the Australian workforce, what we see, of course, is a microcosm of society, different ages, professions and services. And that workforce receives some protection by reason of the minimum protections under the Fair Work Act, which, as His Honour noted earlier, extends to some 14 million Australians. The protections under the Act centre largely on one part of the workforce, I should say, being employees. And we've already heard this evening about some responses addressing who is an employee in the new legislation. But the amendments introduced to the Fair Work Act this year also move beyond employees and now provide some protection for employee-like workers in the gig economy. And that's the first topic we'll talk about tonight. Those amendments reflect societal changes involving the gig economy and related digital platforms. Digital changes also inform the next topic that Phil and I are going to discuss, which is what has been referred to as the right to disconnect outside of working hours for some eligible employees in some circumstances. And the third topic we're going to deal with is changes to the penalties regime in the Act, which is in part a response to reports of significant and widespread underpayment of workers. Finally, we'll consider adverse action proceedings in particular and how those may be evolving along with the changing workplace. Next slide, please.
Catherine, can you tell us about the first development we're going to discuss tonight, which is the ability of the Fair Work Commission to extend minimum standards for employee-like workers performing work on digital platforms and owner-drivers in the road transport industry? Catherine, what are those developments and do you see them as reflective of an evolving workplace?
Thanks, Phil. So we've heard a lot from the ACCC in the last 12 months about digital platforms and the need for regulatory reforms with respect to those platforms. But these platforms are not only the domain of the competition lawyer. All of us in the room here have some exposure to them. So as a competition lawyer who also undertakes industrial employment work, I'm interested in free markets and the way that they intersect with employment responsibilities and industrial laws, including concepts of control of workers, and in particular, workers who don't fall within that traditional dichotomy of the master-servant relationship. So in that regard, we've had an emergence in digital platforms which facilitate the sourcing of on-demand workers at a large scale and the matching of those workers with individuals who require services. And of course, that's what is referred to as the gig economy. In 2019, the Victorian Government commissioned a national survey with respect to the on-demand workforce, and the results of that indicated that 7.1% of respondents had undertaken work through a digital platform in the last 12 months, and 13% had undertaken digital platform work at some point. And unsurprisingly, the survey found that the larger proportion of workers who were more likely to engage in that type of work were young people aged 18 to 34. Now, with respect to the industries most likely to include gig workers, transport and food delivery was the most prevalent, with close to 20% of the industry. Now, I think we've all seen and participated in that shift in the workplace, and I think it would be fair to describe it as a societal change. Now, in some respects, change is normal and it's expected. There have been shifts like this before, such as the changes to the use of email and mobile phones, and of course, remote working, which we're all now very well familiar with. But the shift towards the gig economy, I think, is particularly interesting because it not only reflects a changing technology, but also in how we see and understand what a worker is when compared to our traditional understanding of who perhaps is an employee or an independent contractor.
So Catherine, can you tell us how those developments you've spoken about, how have they been reflected in the amendments that have taken effect recently?
So one of the key changes, Bill, as you well know, is changes to the Act that commenced on the 26th of August this year. and that is the empowerment of the Fair Work Commission to set minimum standards for employee-like workers undertaking digital platform work and regulated road transport contractors who work in the road transport industry. Now, with respect to who is an employee-like worker, Section 15P of the Act provides that a worker must be a party to a services contract and perform all or most of the work under that contract. They must perform work using a digital labour platform or that was arranged or facilitated under the platform, and do not perform any work under the services contract as an employee. There's also 3 criteria, and the worker must satisfy 2 of those 3 criteria. The first is low bargaining power in negotiations relating to the services. The second is receiving the same or less pay than an employee would receive. And the third is having little authority over how they perform work, which I think would arguably cover all workers, including junior counsel. The services contract that the regulated worker is a party to must have a constitutional connection. So, for example, a contract with a constitutional corporation. And of course, as Justice Raper always reminds me, when we're thinking about the Fair Work Act, we need to identify what is the source of power under the Constitution that enables that Act to cover the people that it does. Now, a new Chapter 3A has been introduced into the Act, which is directed to those workers. And there are 3 key elements that are introduced in the new chapter. The first is that there are provisions that enable the Fair Work Commission to make minimum standards orders or minimum standards guidelines for workers performing relevant work. So that is rules about pay and conditions for those employee-like workers. So, for example, record keeping. Minimum standards orders will be legally binding and guidelines will not. Now, as of today, there have already been 3 applications filed in the Fair Work Commission, and Phil's been involved in those, for minimum standards orders under the new section 536JY, each by the Transport Workers Union of Australia. So one covers employee-like workers who perform digital platforms work in the food and beverage industry, so transporting food and beverages by road, so services such as Uber Eats. And that minimum standards order has 24 proposed terms and conditions, including one for minimum safety net cost recovery rates. Another application covers employee-like workers who perform digital platform work transporting goods from warehouses to consumers, so what's known as last mile work and conventional courier work. And so companies like Amazon will be covered by that. And the third application also involves road transport contractors also performing that last mile work. So companies like Aramex might be covered by that, for example. The second main change in this new chapter is the introduction of provisions that enable unions and road transport businesses or platform operators to negotiate collective agreements, improving on those standards. And the third are provisions that will allow the 2 types of regulated worker to complain about unfair loss of work. So that is where you have a digital platform that has suspended the ability of the worker to perform work through that platform by removing access. If the Commission decides that that deactivation, I should say, is unfair, then it may order that the worker have their access reinstated and be paid any income lost by reason of the deactivation. Workers will have to have been performing work on a regular basis for a period of at least 6 months, and it only commences from the 26th of August this year. President Hatcher has issued a statement on the applications. His Honour has constituted an expert panel to deal with consultation between interested parties on the applications, and His Honour has proposed that the Commission obtain the advice of the Road Transport Advisory Group in assessing the application. So it'll be interesting to see what becomes of those. Next slide, please. So while we're thinking of digital technology and access, Phil, have there been any developments with respect to the right to disconnect?
Catherine, I'm sure this may have happened to you as a junior solicitor, but you might be at home on a Monday night and you receive the petrifying sound of a ping on your iPhone notifying you at 9 o'clock that evening of an email from a partner demanding an immediate response to something that can just wait until the next day. Now, as a junior lawyer, you're often convinced that your employment, perhaps your career progression, depends on reading that email, interrupting your Netflix viewing or your time with your kids, cooking dinner or reading a book, doing something other than work, to read that email and reply to that email. Now, everyone in this room here is no doubt familiar with the proliferation of smartphones and technological advances, and we've been through the experiences of the COVID-19 pandemic, where out-of-hours emails, text messages, and phone calls from our employers have become progressively normalised. Employees across society have, in recent years, been progressively expected to be at their employer's beck and call 24 hours a day, 7 days a week. And the boundaries of work and life have been continuously blurred. This has been referred to as continuous connection being the new norm. This has meant not only that employers are intruding more into employees' private time, but that employees are performing a hell of a lot of unpaid overtime. In November last year, the Centre for Future Work did a survey and found that employees were doing an average of 5.4 hours of unpaid overtime a week. Now, for a full-time worker, that tallies up to 281 hours a year, or 7 weeks of unpaid free work for your employer each and every year. Very altruistic. A cumulative total of $131 billion of unpaid work has been found to have been performed by Australian employees each year. The legislature's responded, and they've done that by introducing Division 6 in Part 2.9 of the Fair Work Act, and that was introduced by the Closing the Loopholes No. 2 bill last year.
And so when do those provisions come into force and who do they apply to? And most importantly, will barristers be able to ignore late night emails from solicitors?
Well, the good news is for all the junior solicitors in the room that they did come into force on the 26th of August this year, except if you're employed by a small business, as defined by Section 23 of the Fair Work Act. Have a look at it, check. And if you are a junior solicitor employed by a small business employer, you've got to wait until the 26th of August next year. Sadly, they don't apply to barristers. So, counsel, ignore emails at your peril.
So Phil, what is the right to disconnect and how might it apply in practice?
So new Section 333 capital M, which is another one of these sections with a letter in it, provides that an employee may refuse to monitor, read or respond to contact or attempted contact from their employer or a third party where that contact from the third party is work related outside of their working hours. And they can do that in the event that the refusal is unreasonable. So it doesn't mean that there's a ban on that bothersome partner or that irritating client giving you a call at 10 o'clock on a Friday night or emailing you on a Sunday morning. Rather, the employee has a right, if they wish, to refuse to engage with that contact or attempted contact if it's outside working hours. But that right does not prevent the employer or the third party contacting or attempting to contact the employee outside work hours. The right is a right to refuse. It's reasonable to do so, to monitor, read, or respond to contact or attempted contact. So contrary to some of the media commentary that we've been hearing, some of it by partners and senior barristers who will remain unnamed and certainly aren't here tonight, these reforms really aren't the thin end of the wedge for anyone, in particular our profession. They're not going to be career-ending for young lawyers who reasonably refuse to not read the non-urgent email from the partner or the client. Properly applied, for reasons that we'll come to in a moment, the reforms are capable of addressing some of the systematic and cultural issues that afflict our profession and which Justice Jago referred to in her speech last year, which you're all should be encouraged to read, called Burning Bright Without Burning Out. They're designed to encourage employers to think about the impact of contact with their employees outside of standard work hours and to remember that their employees might have other responsibilities other than work. And as Justice Jago said, they'll also like to sleep, eat and socialise.
So how is unreasonableness assessed?
There are a number of mandatory matters that the parties and eventually the Commission is required to consider under Section 333M, subsection 3. They're non-exhaustive, but they include things like the reason for the contact or the attempted contact, how the contact's made and the level of disruption it's going to cause the employee, the extent to which the employee is compensated to remain available outside of working hours, the nature of the employee's role and their level of responsibility, and the employee's personal circumstances, including any family and carers' responsibilities. So, for example, if the contact is about a work-related emergency, it's made to a relatively senior employee with responsibilities that might relate to that emergency situation, it's probably going to be unreasonable for that senior employee not to actually monitor, read, or respond to the contact. If the contact's a routine inquiry made to a junior employee about something that's not pressing and not urgent, then it's probably going to be unreasonable for that contact to have been made, and therefore the junior employee will be able to, in those circumstances, exercise the right to not monitor, read, or respond to it. Unreasonableness, as we all know, is an objective question assessed in respect to all of the circumstances. But I think, applying these in a common sense, practical way, there should be a fairly bright line in most cases between what's reasonable and unreasonable out-of-hours contact.
And what happens if there's a dispute or a disagreement between an employer and an employee about the exercise of the right?
So you're getting excited there, Catherine, with the prospect of work, but the Fair Work Commission's conferred with jurisdiction under Section 333M to deal with disputes between employees and employers because the employee has refused to monitor, read or respond to contact or attempted contact. Disputes of the kind the Commission's conferred with jurisdiction to deal are those where the employer reasonably believes the employee's refusal is unreasonable, or the employer asserts the refusal is unreasonable and the employee reasonably believes the refusal is reasonable.
Right.
That makes sense, doesn't it?
Yes. Can the parties go straight to the Commission, or do they need to try and work things out themselves first?
The parties are obliged to try and resolve the dispute by discussions at the workplace level first. If those discussions don't resolve it, then a party can apply to the Commission for an order under Section 333 capital P, or for the Commission to otherwise deal with this dispute by exercising its dispute resolution powers and functions.
And what powers are conferred by the Commission in respect of the dispute?
The Commission's got a discretionary power under subsection 2 in Section 333P to make any orders it considers appropriate other than orders requiring the payments of pecuniary amounts. The power depends upon whether there's been an unreasonable refusal by an employee to monitor, read or respond to contact, or the employee's refusal is not unreasonable and there's a risk the employer might take disciplinary action against them or alternatively keep contacting them. The Commission's required to make orders that are directed to the particular circumstances that it finds exist and can, in broad terms, make orders preventing the employee. So an employer can go off and make one of these applications, prevent the employee from continuing to unreasonably refuse to monitor, read or respond to communications, prevent the employer taking disciplinary or other action, or prevent the employer from continuing to require the employee to monitor, read or respond to the communications. And the Commission's got to deal with these matters quickly. It's got a mandate under Section 333 capital P sub 3 to deal with to start to deal with the application within 14 days.
And what happens after an order is made?
A person's prohibited by Section 333 capital Q from contravening a term of the order. That provision's a civil remedy provision. So if you breach it, you'll be up in this court or in the circuit court with an application for orders under Section 545 or for an application for penalties under Section 546. Now, for all those junior lawyers here tonight who want to commence proceedings in the Commission to vindicate their right to disconnect, there's a table outside with our business cards on it, and you're welcome to collect them on your way out. Next slide, please. So when we're focusing and talking about workers' rights, another issue that has been prevalent recently is underpayment of workers, including gross underpayment and wage theft. And one of the key changes to the Act has been to increase maximum penalties for underpayment contraventions, including serious contraventions. Catherine, can you talk us through those?
Yes. So we have now Division 1, Part 11 of Schedule 2 to the Closing Loopholes Act, which amends penalties for certain types of contravening conduct, creating a new category of civil remedy provisions and a new test for liability for serious contraventions. So if we deal with serious contraventions first, as we know, the Fair Work Amendment Protecting Vulnerable Workers Act in 2017 inserted the concept of a serious contravention of certain civil remedy provisions into the Act as Section 557 capital A, and that commenced on the 15th of September 2017. However, in the last 7 years or so in which those provisions have been in operation, there have only been a very limited number of decisions in the court which have given substantial consideration to those provisions. Most recently, of course, Justice Katzmann's 2 decisions in Fair Work Ombudsman and Sushi Bay, and Fair Work Ombudsman and Blue Sky Kidsland. Now, one reason there have only been a limited number of these cases where a serious contravention has been alleged or found, it might be because applicants are concerned about their ability to establish first the knowledge standard, which requires a person to have knowingly contravened the provision, and perhaps there was a view that that was a higher threshold than it arguably was. And secondly, there was a need to establish that the person's conduct constituting the contravention was part of a systematic pattern of conduct. Now, the Act has amended these provisions to make out a serious contravention from one committed knowingly and systematically to a contravention committed knowingly or recklessly. The revised explanatory memorandum provides that the definition of reckless adopts a subjective belief test, so commensurate to the test in the criminal law, to reflect the seriousness of these types of contraventions, which attract higher penalties under the Act.
It's a perennial question. What does recklessness mean?
Well, we've now got a definition in subsection 2 of section 557A. It provides that a person is reckless as to whether a contravention would occur if the person is aware of a substantial risk that the contravention would occur, and having regard to the circumstances known to the person, it is unjustifiable to take the risk. Now, I think we can all look forward to some interesting decisions of the court with respect to what unjustifiable means in the context of the risk. Now, in addition to section 557A, the Act has been amended to increase the maximum penalties applicable to body corporates for select civil remedy provisions, including underpayment provisions, from 300 to 1,500 penalty units, and for serious contraventions, from 3,000 to 15,000 penalty units. So that's a significant increase, and we've put some figures on the slide, but hopefully my maths is correct. Those increased penalties do not apply to small businesses or individuals. And I'd also note that the penalties for non-compliance with a compliance notice, which is an important tool that is exercised by the Fair Work Ombudsman, have also doubled. And those amendments came into force in February this year.
Are there any more amendments in the pipeline, Catherine?
Yes, I'm quite excited by these. There's further amendments made which will be commencing in January next year that introduce the concept of gains-based maximum penalties for contraventions associated with an underpayment amount in section 546. So that will mean in certain circumstances, the penalty that could be applied is 3 times the value of the underpayment or the relevant penalty unit for the contravention. Now, the concept of gains-based maximum penalties is not new. There are provisions in the Competition and Consumer Act that allow for that. And penalties of this nature are broadly intended to serve the primacy of deterrence, as we all know. The full federal court in Volkswagen and ACCC, their Honours Justices Wigney, Beach and O'Brien provided some useful findings with respect to those gains-based penalties, noting that in that context, in the case of a contravention of the Competition and Consumer Act, where conduct is not easily, where contravening conduct is concealed and is not easily detected, then deterrence may justify a penalty that is many multiples of the profits made from the contravening conduct. So among other things, of course, to deter contraveners from the view that paying a penalty is simply an acceptable cost of doing business. Now, of course, concealment is only one factor that the court would have regard to in determining what is an appropriate penalty. And so we look forward to seeing how these provisions are dealt with in the Fair Work context. I would note as well that applicants will need to think very carefully when they apply for penalties, whether they want to go down the gains-based route or whether they would be looking for simply a penalty imposed with respect to the specified penalty units. And again, it'll be interesting to see how the court applies this, but I think we can draw on the jurisprudence from other provisions such as those in the Competition and Consumer Act when we consider this going forward. Next slide, please. So Phil, finally, can you tell us if there's been any developments with adverse action?
Very quickly, because I can hear drinks about to be served. Last September, the High Court in the Qantas TWU case pronounced on the correct construction of Section 341 little b of the Fair Work Act, which, as we all know, prohibits adverse action to prevent the exercise by a person of a workplace right. The High Court unanimously upheld Justice Lee's construction of the provision, which the full court had unanimously upheld previously, that the workplace right the perpetrator of the adverse action sought to prevent by taking the action need not be in existence or capable of exercise at the time of the action. What Justice Lee had found was that Qantas in November 2020 took adverse action by sacking its ground handling workforce at that time to prevent them in 2021 exercising rights to take protected industrial action and engage in collective bargaining. Now, they couldn't take action or engage in bargaining at that time because, amongst other things, the Qantas employees' enterprise agreement hadn't reached its nominal expiry date. Qantas argued we couldn't be said to have prevented anything because the workplace rights we supposedly prevented employees from exercising couldn't have been exercised in November 2020. The High Court said that Section 341 was not, as Qantas had contended, a definitional provision. It enacted substantive law, it identified what a workplace right was, and it did not temporally limit the protections under Section 340. It was Section 340 that set out the bases upon which the protection of workplace rights operated, and those were not controlled by Section 341. So ultimately, the High Court set out that the provision extended to protect persons from adverse action taken to prevent the exercise of rights, regardless of whether those rights could be presently exercised or were even in existence. It was a provision concerned with what the plurality described as preventing preemptive strikes against people from exercising rights in the future.
And have there been any legislative developments that might impact on adverse action proceedings in particular?
Yes, the right to disconnect is enshrined in Section 333M, subsection 4, to be a workplace right. So when you're considering grabbing our business cards on the way out, remember that your employer is prohibited from taking adverse action against you because you've exercised, proposed to exercise, or have the workplace right to disconnect.
Thank you.
Well, thank you to our speakers tonight, and thank you all for coming as well. Now, those of you in Brisbane, Sydney and Melbourne are welcome to join us for drinks. Good night.